What's going on? YouTube, listen up, young elder gang. This is Ted Strokes at you with another banger. Please make sure you like, subscribe, and share this video. Fam, I hope this video get at least 100,000 likes in this video. You will find history definitions, scripture information, and best of all, what we Americans have been deprived of from the beginning. The truth, keep in mind this content used in this video is intended for entertainment, educational and informational purposes only, and does not constitute legal advice or create an attorney-client relationship. You should not act upon any information on this video without seeking the advice of a competent attorney for your specific situation. We will give you the total truth as we best understand it today. Be sure to hit that like button, young elder gang. Hit that subscribe button if you're new to the channel. Hit that bell and don't forget to check back with us every day for new content. When you see courtroom drama on TV, you're only catching a glimpse. Real court cases are structured, not just shouting matches. Think of a trial as a 3-act play: pre-trial, trial, and post-trial. Each act has its own rules and drama. If you don't know the process, you'll get lost, and that's costly. The pre-trial phase is the homework, preparation, investigation, and paperwork. The trial is the main event: witnesses, arguments, and evidence. Post-trial is where sentences are handed down, appeals are filed, and the verdict's consequences play out. Understanding these phases is critical for everyone: plaintiffs, defendants, jurors. The system is built for fairness, but only if you know the rules. There are strict procedures and deadlines. Miss one and you might lose before you start. Whether it's criminal or civil, the structure is similar. The stakes are liberty or money, but the goal is truth and fairness. Each phase ensures both sides can prepare, present, and respond to the outcome. So, let's break down each phase and see how the system really works. Don't just watch the show, understand it. Let's get started. The pre-trial phase is where the groundwork is laid. It starts with a complaint. Plaintiff or prosecutor files, defendant responds. Ignore it, and you lose by default. Discovery is key. Both sides exchange evidence, documents, and witness lists. No surprises allowed. Lawyers send interrogatories, written questions under oath, and conduct depositions to question witnesses. Motions are filed, requests for the judge to act, like suppressing evidence or dismissing the case. Judges' rulings on these motions can end a case before trial. Most cases settle here, plea bargains or agreements, because trial is risky and expensive. If no deal is reached, both sides sharpen their arguments for court. Pre-trial is about preparation, strategy, and negotiation. It's where cases are often won or lost before anyone steps into the courtroom. If you're not ready now, you never will be. In criminal cases, arraignment is the first big step. Charges are read, and the defendant enters a plea. Plead guilty, and you go straight to sentencing. Plead not guilty, and you're headed for trial. Bail is set to ensure the defendant returns for court. Pay up, show up, or face arrest. Judges weigh the crime, criminal history, and flight risk before deciding on bail. Discovery is crucial. The prosecution must share all evidence, even if it helps the defense. This is the Brady rule. The defense isn't required to share as much, but must disclose alibis or expert witnesses. This phase sets the ground rules. Charges are clear. Freedom before trial is decided, and both sides see the evidence. Surprises are out. Fairness is in. If you have a strong case, you know it now. If not, it's time to face reality. The groundwork for the trial is set here. Be honest with yourself and your lawyer. The real fight is about to begin. Now we're in the courtroom, the trial phase. It starts with jury selection. Lawyers weed out bias to find fair jurors. Opening statements follow. Each side previews their case, setting expectations for the evidence. The prosecution or plaintiff presents first, calling witnesses and introducing evidence. Direct examination lets witnesses tell their story. Cross-examination tests their truthfulness. Lawyers use cross to poke holes and challenge credibility. No leading questions on direct, but anything goes on cross. This back and forth is where stories are built, or fall apart. After cross, A brief redirect may clarify points. The trial is a test of evidence, not theatrics. Jurors watch, listen, and judge based on what's presented. Every question, every answer matters. This is where the facts come to light. When the prosecution or plaintiff rests, the defense can present its case or argue the other side failed to prove theirs. In criminal trials, the defendant isn't required to testify or prove anything. The burden is on the prosecution. If the defense presents evidence, it follows the same process: direct and cross-examination. The prosecution may rebut new defense evidence, and sometimes the defense responds with surrebuttal. Closing arguments come next. Lawyers summarize, persuade, and connect the dots for the jury. The judge then instructs the jury on the law and the standard of proof. In criminal cases, it's beyond a reasonable doubt. In civil, it's more likely than not. The jury deliberates in private, discusses the evidence, and votes. When they reach a verdict, it's read in court. This is the climax, the moment of truth. The process is designed for fairness, not drama. The verdict is the result of everything that came before. The verdict isn't the end. Welcome to post-trial. Losing sides can file motions for a new trial or to overturn the verdict, but these are rarely granted. In criminal cases, sentencing follows, a separate hearing where punishment is decided. Judges weigh the crime, record, and statements from both sides before imposing a sentence. In civil cases, the judge enters a judgment, how much the loser owes. Collecting money isn't automatic. Winners may need to garnish wages or seize assets. If a serious legal error occurred, parties can appeal, asking a higher court to review the trial for mistakes. Appeals are about legal errors, not new evidence. The appellate court can affirm, reverse, or order a new trial. The process is slow and costly, a last resort for fixing big mistakes. Justice doesn't end with the verdict, it's enforced and reviewed. A motion in court is a formal request made by a party in a lawsuit to a judge for a ruling or an order on a specific issue. This request can be to decide on a procedural matter, dismiss the case, admit or exclude evidence, or take other actions that affect the course of the lawsuit. The party filing the motion is known as the movant, and their request must be supported by legal arguments and often evidence. Motions are used to resolve disputes, narrow the legal issues, or move the case toward a resolution without a full trial. They can be filed at various stages of a case, from before the trial even begins to after a final order has been issued. Common motions include a motion to dismiss a case, a motion for summary judgment, to get a ruling before trial, a motion to compel discovery, or a motion to modify an existing court order. The movant files a written request with the court, which often includes a supporting document explaining the legal basis for the request. The opposing party is then given an opportunity to respond to the motion. The judge will consider the motion and the opposing arguments before making a decision. The ruling can impact the case in significant ways, such as excluding key evidence or even leading to a dismissal. In a court case, discovery is the pre-trial phase where parties formally exchange evidence and information to prepare for trial or settlement. This process helps eliminate surprises, clarify the issues, and build a strong case by using tools like written questions, requests for documents, and sworn testimony. Exchanging information. Parties exchange evidence and information related to the case. Purpose. The goal is to prevent a trial by ambush, by allowing each side to understand the other's evidence and strengthen their own case. It also helps narrow the issues in dispute and can lead to a settlement without a trial. Mandatory participation. All parties are required to participate in the discovery process. It is not optional. Interrogatories. Written questions that one party sends to another, which must be answered in writing under oath. Requests for production of documents. A request for the other party to produce documents and other tangible items for inspection. Requests for admission. Written statements that one party asks the other to admit or deny. This helps establish facts that are not in dispute and can simplify the case for trial. Relevance. Parties can only request information that is relevant to the case. Consequences. A party can face consequences for failing to respond to discovery requests, such as having statements deemed admitted by default. Court oversight. The court will balance the need for information against the burden of producing it. The plaintiff is the person or entity that initiates a lawsuit, while the defendant is the person or entity being sued. The plaintiff files a complaint to seek a legal remedy for a perceived wrong, and the defendant must respond and defend themselves against the claims. In a civil case, the plaintiff has the burden of proving their case. Plaintiff role: the party who starts a civil lawsuit. Purpose: to seek a legal remedy, such as monetary damages or in order to stop certain conduct. Responsibility: to file the initial complaint, which outlines the legal and factual basis for the claim, and to prove the claims are true. Example: in a car accident case, the person who was injured and files a lawsuit would be the plaintiff. The defendant role: the party being sued or accused in a legal case. Purpose: to respond to the plaintiff's claims and defend themselves against them. Responsibility: to answer the plaintiff's complaint and present a defense. If they fail to respond, they can lose the case by default. Example: in the same car accident case, the driver who allegedly caused the accident would be the defendant. That's the trial process: pre-trial, trial, post-trial, each phase with a purpose. Pre-trial ensures both sides are prepared and prevents ambushes. The trial tests evidence in the open, with impartial jurors and strict rules. Closing arguments and jury instructions guide the final decision. Post-trial allows for correction of errors and enforcement of judgments. Sentencing and appeals are crucial for justice and fairness. Even collecting a judgment is part of the system's promise. The whole structure is about due process. Everyone gets a fair shot, and the rules apply to all. It's not perfect, but it's designed for fairness. Understanding these phases is key to navigating the system. Justice is a marathon, not a sprint. Be ready for every step. Case closed.